Major breaking news. The United States Court of Appeals for the Third Circuit that covers Delaware, New Jersey, Pennsylvania, in a decision by Judge Thomas Hardiman, has declared that nonviolent felons do not necessarily lose their Second Amendment rights forever in a major victory on behalf of Bryan Range. That's Range versus the Attorney General of the United States, Merrick Garland. Stay tuned. This is a big deal, folks. We'll talk about it when we get back. Hey folks, I'm Mark Smith, host of the 4 Box of Nine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check that out. A lot of lessons there for Americans. Okay, folks, breaking news here. The United States Supreme Court for the Third Circuit, that's based in Delaware, Pennsylvania, and New Jersey, has come out with a decision in the Range versus Merrick Garland case. I told you this is a big deal, and it is a big deal. The opinion by Judge Thomas Hardiman says that under 922G1, which is the felon in possession statute of the Federal Gun Control Act of 1968, there are instances where people can be convicted of a felony and still retain their Second Amendment rights for the rest of their lives. This is a huge deal. I'm going to hit about 9 points here, and then we're going to get into some of the details in future videos. This is a case that has the potential to go to the United States Supreme Court and be the next Second Amendment case to the Supreme Court. We'll talk about that in future videos, but watch this one carefully. I predicted that we would win this Range case. We have won the Range case in a big way. A great opinion from Judge Hardiman and the Third Circuit. Remember, this was en banc. This was not a 3-judge panel. This was the entire Third Circuit weighed on this, and not only did we win the judges that I anticipated we would win with, we actually won. Hear me carefully here. We actually won in the majority opinion 2 Democratic, that's right, 2 Democratic appointees to the federal bench, specifically Judge Greenaway, who was a Barack Obama appointee, and Judge Freeman, who, believe it or not, was a Joe Biden appointee and a former public defender. So we literally have 2 Democratic appointees to the Third Circuit Court of Appeals have ruled in favor of the Second Amendment in this Range case, in addition to sort of the what I don't want to call them the usual suspects, but the people that we would anticipate ruling in favor of the Second Amendment in the Third Circuit, people who already have a known track record in support of Second Amendment rights and the proper interpretation. Obviously, there was a few dissents here. We'll get into those in future videos. Bottom line, this is a major win. Let me hit the highlights. Just to jog your memory, Bryan Range challenged the fact that he lost his gun rights forever because over a decade ago he lied to the tune of an extra he I think omitted like $500 in lawn mowing income on a food stamp application, which was technically fraud under a state law. I believe it was in Pennsylvania. When he applied for food stamps, he was convicted of that misdemeanor, but because that misdemeanor carried with it a possibility of more than 1 year in prison, he was technically a felon under 922G1, which is part of the gun control line, and as a consequence, he lost his gun control, I should say he lost his gun rights forever and his Second Amendment rights forever. He then brought this lawsuit. It went up to the Third Circuit Court of Appeals. The 3-judge panel actually ruled against him, saying that he did not have the right, notwithstanding the fact that Nysurpa versus Broom was decided in 2022. The Third Circuit Court of Appeals heard the case en banc, which means that every single active judge on the Third Circuit Court of Appeals was able and did indeed hear this major argument, which I think took place a couple months ago in February. Huge argument that we all tracked. I talked about extensively on this channel. I predicted that I thought we were going to win this. I thought it would be a big win, and it's been proven correct. We did, in fact, win today. Specifically, the court said that applying the Nysurpa versus Bruin standard in the text of the Second Amendment, nonviolent felons such as Bryan Range cannot be denied their Second Amendment rights. They did say this was an as-applied challenge just with respect to Mr. Range in this case, but they set a precedent by virtue of their interpretive methodology that can be used by people in Delaware, in Pennsylvania, in New Jersey, and I believe also in the Virgin Islands, by the way, to bring challenges if you're a nonviolent felon or you are a felon technically under 922G1, but you're not violent in terms of it. You now have the possibility of bringing a suit to get your gun rights back based on this precedent by the Third Circuit. Now, let me hit the highlights here. I should mention right off the bat, the court made this very clear. This is the first critical point to understand going forward that you can apply in other cases. The court specifically said that when you read the text of the Second Amendment, which is the right of the people to keep and bear arms, the people includes all Americans, not just responsible, law-abiding Americans. And why this is important is the word people, they say, appears in several parts of the Bill of Rights, like the Fourth Amendment and so on. And that refers to all the American people. So on the basis of the text of the Second Amendment, people like Bryan Range and others who've been convicted of crimes all fall within the text of the people. And the only way, once you fall within the text of the people, that you can lose your Second Amendment rights is if there's some longstanding historical tradition. And again, I'm going to read you the language here. We've talked repeatedly about this, that it's up to the government to come forth and show a longstanding historical tradition of gun laws that existed since the time of the founding. Other ways they lose. And that is what the Third Circuit said. The Third Circuit said that once the text is implicated, which obviously this does because they're denying Mr. Range the ability to have a firearm, it goes on to say, once that occurs, we, quote, we now ask whether the government can strip Mr. Range of his right to keep and bear arms. To answer that question, we must determine whether the government has justified applying 922G1 to Mr. Range. Here's the key language that I've been hammering home on the Four Boxes Diner. Applying 922G1 to Range, quote, by demonstrating that it is consistent with the nation's historical tradition of firearm regulation, period, close quote. There has to be a historical tradition of firearm regulation, which means actual laws on the books that are actually enforced going back to the founding and beyond. The court said here that, guess what? The government could not possibly do that in this particular case dealing with Mr. Range. It goes on to say, that was kind of the first critical point. Once the text is met, you go to the burden shifts to the government. When in doubt, throw it out. As you know, that's my basic rule. You can take it and use it. Once you shift that burden to the government had to come forth with a burden. They had to satisfy their burden that Mr. Range could be denied his Second Amendment rights, and they simply failed to do so. And the Third Circuit said, you didn't even come close. Now, here's some of the other critical language from the Third Circuit opinion that other litigants, other lawyers, other courts, law clerks, whatever, can consider using that I think is very persuasive when they read this opinion. And I'll put a link to the opinions down below, of course. Specifically, they quote the language from Heller. If you remember in Heller, in part 3, I believe it was, there's a reference that says that longstanding there's a presumption that longstanding prohibitions on the possession of firearms by felons is still constitutional. But the court says that Heller, number one, never addressed it specifically because Dick Heller, the plaintiff in the Heller case, was obviously a law-abiding citizen, so they didn't have to get to the question. And also in Nysurpa versus Bruin, again, the plaintiffs in that case were undeniably law-abiding citizens. So they said that doesn't tell us what the people consist of in any historical traditions. And the fact that Heller just generally made it as passing reference to the presumption is these laws are presumptively constitutional. And of course, we know, and this is what the Third Circuit says, that something that is presumptively constitutional may still be unconstitutional because you can rebut a presumption. Like there's a presumption of innocence when you go to criminal court, but that government can rebut that presumption of evidence, a presumption of innocence by showing all this evidence that you indeed committed the crime, for example. So basically they said that we understand that the court in Heller, the Supreme Court in Heller says there's a presumption that prohibitions on possession of firearms by felons is presumptively constitutional, but they said that they never really did any work or analysis on that. We, the Third Circuit, are going to do that work. And when they did that, they said the government has fallen far short of being able to show that Bryan Range should be denied his gun rights for the rest of his life. That's a no can do, and that's what the Third Circuit said. The next thing is, and this is important, and I'm going to think long and hard about what this means, but they made it very clear that the laws at the time of our founding that barred certain people from being able to have firearms, such as the Tories, which are the British loyalists, the Native Americans or the Indians, the Quakers, the Catholics, and the blacks, they basically said that none of these stuff were a sufficient analog to show that they could take away the guns from Mr. Range, not least of which, by the way, they said that Mr. Range is not a loyalist, not a Native American, not a Quaker, not a Catholic, not a black. So basically what they said is he doesn't even fall into any of these categories to the extent that these would even conceivably be historical analogs. And of course, he said, the court goes on to say that a lot of these would clearly not fly today because it would be illegal to discriminate against Catholics or blacks or Native Americans today as a matter of the 14th Amendment and beyond. So they said none of these analogs can possibly work to take away the gun rights of Mr. Range in this case. Very powerful language there. The next thing they say is they reject the government's argument. The government had argued that at the time of the founding, if you committed a felony, they could execute you, meaning they could hang you or put you to death, and therefore you obviously would, by definition, lose your gun rights. But here's what the Third Circuit said. They said, yeah, we acknowledge that certain people could be hanged and given the death penalty at the time of the founding, and by extension lose various rights, such as their right to bear arms, because they be, well, dead. But what they go on to say here is the Third Circuit says, look, but that doesn't tell us anything about this case here where someone has been convicted of a crime, they've served their sentence, and now they're free to go about their business. And there's no example at the time of the founding where someone like that was denied the ability to have firearms. So they rejected this notion that the fact that you had executions at the time of the founding somehow could justify taking away gun rights forever for people that have already served their criminal sentences. So again, the Third Circuit said that. Then the Third Circuit goes on to say they reject forfeiture laws. As you know, forfeiture laws basically say that if I'm driving a car, I'm going to give you a general example. I'm driving a car and I've got a gun and I do something illegal and I use the gun in the car or something like this to commit the crime. Under forfeiture laws, it is sometimes the case that the government can, punish me by putting me in jail, but they can also take away the instruments of the crime, like my car or my wallet or my gun, whatever it is. There's the notion of forfeiture laws. But the critical thing that the Third Circuit said here is that when you deal with forfeiture laws, under those laws, you lose the instrument that you use to commit the crime itself. So if I use, this microphone to commit a crime, I might lose this microphone, but that does not bar me from going out to buy another microphone. So they said, even if you could say there's a law that allows the government to cause a firearm to be forfeited, that firearm you may lose. That is not a basis to prevent someone from being able to go out and acquire another firearm that's unconnected to the crime that was committed with that firearm. That's kind of the concept here. So they rejected forfeiture as a basis for taking away Bryan Range's rights forever. The next thing is they talk about some other courts of appeals that have come out the other way, but they said none of those are persuasive because they all came before NYSERDA versus Bruin, and they're contrary to the Supreme Court, so we don't need to listen to them. The other thing to keep in mind, I've told you that there's this ongoing debate between dangerousness on the one hand and virtuous on the other hand. If you look at footnote number 9 of this opinion, the Third Circuit really did not get into this. They said we don't need to do this because, frankly, the government fell so far short when it came to Mr. Range, they didn't feel the need to even need to get into this line drawing because it was clear Mr. Range was entitled to get his Second Amendment rights back under the Constitution and NYSERDA versus Bruin. Now, the next thing I want to say, and we're going to do a very deep dive on this in a future video, is whether or not Range versus Merrick Garland, this case here, whether or not the Department of Justice will seek certiorari to the United States Supreme Court and whether it will be granted. I'm not going to answer that question here. It is certainly quite possible that this could occur. Specifically, if you think about it, the Department of Justice almost has to seek cert because right now, this is the binding precedent on 3 states, Pennsylvania, Delaware, and New Jersey, and the Virgin Islands. And this is so important because the U.S. attorneys that are going to be determined who to prosecute, right, as a felon in possession. So if they uncover a felon with a gun, will they charge them under 922G1? That's going to make life a lot more complicated because the U.S. Attorney's Office may fear that they may not be allowed to under this precedent, so they may want to seek clarification from the United States Supreme Court. And last but not least, I have a feeling, here's my best prediction, I have a feeling that a lot of people in those 3 states, and maybe even beyond, but certainly in those 3 states, are going to start to bring civil lawsuits saying that, hey, I was convicted of a quote-unquote felony 25 years ago or 10 years ago or 8 years ago for like a financial crime, like, yeah, I stole money from my client or I screwed something up under the SEC rules or whatever, but I'm clearly more like a Bryan Range than I am a violent cartel member. Therefore, I should be like Bryan Range and get my Second Amendment right. So I think you're going to see a lot of civil lawsuits in the Third Circuit Court of Appeals and in those 3 jurisdictions. So I think the Department of Justice is likely going to have to see certiorari, but there's a lot of moving parts here, so I don't want to make a prediction just yet. We'll talk about the dynamic of that in a future video. The last thing I want to say is, again, this is very important. The author of this decision is important. The author of this decision in Range versus Merrick Garland is Thomas Hardiman. This is not insignificant. You see, Judge Thomas Hardiman of the Third Circuit Court of Appeals was on the short list to be a Trump-nominated Supreme Court justice. He was in competition with Neil Gorsuch and also was in competition to some degree, as I understand it, with Brett Kavanaugh to get those 2 slots. So, so Judge Hardiman is considered a Supreme Court level justice, even though he's a judge. But his opinions and views are so highly respected that even though he's not a Supreme Court justice, his views, his opinions are going to be taken far more seriously by the United States Supreme Court than they might take the views of other judges out there who, as you've seen by watching this channel, shall we say, don't always get it and don't always get it right. And perhaps you can explain it to them and they may not always understand what you explain to them. Nevertheless, that is not the case with Judge Hardiman of the Third Circuit, and everyone understands this on all sides of the political spectrum. He's a very serious, earnest judge, and his views are to be taken seriously, and the Supreme Court will take them seriously, which is a good sign for the right to keep and bear arms. Okay, folks, I hope you learned a little bit something here today. We're going to talk a lot more about Range down the road and what it means for your gun rights and different ways it's going to implicate all sorts of things in America. But for now, just make sure you subscribe to the Four Boxes Diner, and if you haven't done so, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.